All right, party people. This your man Griff. The NNA background check. This has been a hot topic issue for some years. I'm starting to understand what the issue is. I understand the concern on both parts. The reason why I don't have a problem with the NNA background check is this here. Until you do a background check that consists of all of this, that NNA background check ain't nothing compared to what I had to do back in 2002 when I was getting my top secret clearance. And just so y'all can see, 12:27 at night. So I'm up late. I was getting ready to go to bed. I see stuff on, this time on Instagram, complaining about the NNA and how much money they making and all this, that, and the other concerning the background checks. So I said, well, you know what? I never really looked into it. I said, I probably need to. But that what I just showed you, that was from 2002. I've had multiple background checks done. This is for work. This was after I got out of the military. That wasn't even while I was in the military. And the background checks that I did that was conducted on me cost like $20,000 to do. In-person, face-to-face interviews, fingerprinting, lie detectors, all kinds of stuff. So you talking about being intrusive, wanting to know my complete full work history, talking about from the time I was like 15 years old all the way up to at the time I was in 2002. My wife's background, I was married prior, so they wanted to know her background, my parents' background, all of my bank account information, credit report, you name it, they pulled and they interviewed family and friends to ascertain whether or not I was trustworthy, to be trusted with information that they deemed classified and sensitive. That's what I had to do. This NNA background check is nothing compared to that. So, so there have been arguments about the legality of it. And the argument is sound to a particular point, but there's some other things that they're not taking into consideration, whether through ignorance or they know they're just not talking about it, and it gives them a platform to argue about concerning it. One of the things I've always said, notaries are the most important, but the least powerful. And who have I said is the most powerful? Is the lender. The person who controls the money is the most powerful one in the situation. So when you got billions of dollars at stake, especially within the real estate market, sorry about that. Oh, okay, that's just bank. Okay, that's just the bank updating. I had deposited some money and just let me know that. So with billions of dollars at stake, the people who have the money and control the money are going to control how people who are part of the process are allowed to come in. And if they decide to put certain barriers and restrictions, and if you don't meet those criteria, you're not getting in. And the only way you can do what you do within the loan closing realm without following that particular requirement of doing a background check is to get your own business. Meaning you go get your own clientele. That means you have to communicate to the title company and the lender, and they will have to say, we don't require you to do a background check. And in some cases, you can have that. But when you're dealing with the signing agents, companies, and all of that SWP, that's a different beast. And you need to understand that. And I get the argument, and I'm not opposed to it. But we have to look at this from all angles. And people aren't doing that. They're just looking at it from their individual angle of the notary, not the grand scheme of things. So I'm gonna show y'all some stuff here. Again, this I think yesterday I talked about I was using DeepSeek. I actually was using Gemini, but today I'm using DeepSeek, Gemini, ChatGTP, and Claude. And I'm gonna give you links to all of this stuff in the description. If for some reason I forget to do it or forget a link, make sure you remind me. So I asked a simple question here to DeepSeek. I said, I need some help with this issue in the notary signing agent and mobile notary business. There are some individuals that say the National Notary Association requirement for notaries to do an annual background check is illegal. Now, some are saying it's illegal, some are saying it's not, but this is the area that I've heard the most, and I've heard that also it says, and it's violating the Fair Credit Reporting Act, which you hear some people say the FCRA. Can you help me understand if this is true? So it says, of course, this is a very hot topic in the mobile notary and notary signing community. It is crucial to understand the legal landscape. Let's break this down clearly. The short answer, the claim that the National Notary Association requirement for an annual background check is illegal under that FCRA, in most cases, is not true. That is illegal. However, the process must be conducted in strict compliance with the FCRA. The controversy usually arises not from the requirement itself, but how it is implemented by the NNA or perceived by the notary. Let me zoom in a little bit more there. Okay. For those of you who got small devices, let me go back to the question so you can see that. Give you a moment to read it. So this is the question that I asked based off of what I've heard multiple people say, not just the people on Instagram, TikTok, but actually conversations that I've had with individuals, men and women. So as it goes into explain, it said, look at this, just look at the arguments on both sides and the legal framework. Sorry about that, y'all. Late, throat scratchy already. So it says the National Notary Association position. The NNA is a private organization that provides training, certification, and insurance for notaries. Does it do that? Yes, it does. Their flagship certifications and notary signing aid for notary signing agents is highly recognized by the lending and title industries. So you have people in those two industries that recognize this certification, and they we like this. Okay, they like this. So when you talk about getting rid of the NNA, you're talking about getting rid of something that those two entities hold dear, and they like, and they respect, and they want to see more of for whatever reason. Okay, they look at it as the holy grail. I'm just telling you that's how they look at it. So if you're going to take that away from them, what are you replacing it with? Why they require background checks? The NNA argues that the notary signing agents handle extremely sensitive documents and large sums of money in escrow instructions. Lenders and title companies demand that the professionals handling these transactions have a clean background to ensure integrity, minimizing fraud, and manage their own risk. Now, here's the thing, real quick. We know there's some shady notaries out here. You got shady notaries. If you got notaries out here teaching you some bull jive, what makes you think they won't steal somebody's personal information? So you can't sit here and act like, oh, we're all trustworthy. No, the heck we're not. There's some snakes in the grass out here. I've said this many times. The only reason why some people are actual notaries right now is that when they did a background check, you hadn't caught a felony. That's the only reason why you are a notary for some of you, not all, for some, that you did not catch a felony at that time. You didn't have one already at that time. All right. So the requirement of the background check is a prerequisite for obtaining and maintaining the signing agent certification. It is not a requirement to be a state commissioned notary public. So it recognizes, okay, see, that's why I say, don't tell me AI don't understand what the heck is going on when you ask the question right. So we all know that it's not a state required thing, okay? But is a requirement to get work, excuse me, for most companies in the mortgage signing industry. The Fair Credit Reporting Act, the key law. This is a federal law designed to promote accuracy, fairness, and privacy information on files in the files of consumer reporting agencies like companies that run background check. It sets rules for how these reports can be used for employment purpose. Okay, now that's key because I know they well, we're not employees. We're gonna cover that in a second. The core compliance steps for an employer or organization acting like one. A clear and conspicuous disclosure. You must inform the person, the notary, in a separate standalone document that a background check may be obtained. You cannot bury this consent in another document. Written authorizations must give the person written authorization before obtaining. You must get the person's written authorization. That's why when you do it, you have to sign so many of those little documents. You're giving them permission. Adverse action process. This is the most critical part. If you plan to take adverse action like denying or revoking certification based in whole or in part of the background report, you must follow a two-step process, meaning in this case the NNA. Pre-adverse action notice. Before you take the final action, you must give the person a copy of the background report, a copy of a summary of your rights under the FCRA, and a reasonable period of often 5 to 7 business days to dispute the accuracy of the report. The final adverse action notice after the waiting period, if you still decide to take the adverse action, you must notify the individual again, providing specific details, including the name of the consumer reporting agency, the illegal argument and its flaws. Okay. So this is the argument where they're saying it's illegal, but the flaws behind this argument. The individual claiming the requirement is illegal typically base the arguments on a few points, which often misinterpret the FCRA. It's not for employment. They argue that since notaries are independent contractors and not employees of the NNA, the FCRA does not apply. This is incorrect. The FCRA definition of employment purposes explicitly includes evaluating a person for engagement as an independent contractor. So I've heard that argument from a buddy of mine. The question is, if you're just looking at this part and not understanding what they mean by employment purposes, you can misconstrue and have the wrong argument basis. They do not allow the adverse action, they do not follow it. And this is where I think the NNA has probably gotten in trouble in the past. It may have had a lawsuit against them concerning this. It's more than likely that they didn't follow this. This is the most valid area of complaint. In the past, some notaries have claimed the NNA denied their certification based on a background check without properly following the pre-advised and adverse action steps. If the NNA failed to do this, they would indeed be in violation of the FCRA for that specific instance. However, this is a failure of the process, not a reason that the requirement itself is illegal. And what requirement? To get a background check. It's a monopoly, restraint, or trade. This is a separate legal argument that suggests the NNA uses market power to force notaries into an unnecessary and costly requirement. While this is a business practice compliant, it does not make the background check itself illegal under the FCRA. So then it says the conclusion and practice advice. The requirement is generally legal. The NNA requirement for annual background check of the certification practice to manage the risk and ensure quality of for its clients. The title companies and lenders permits this as long, the FCRA permits this as long as the proper procedures are followed. The NNA must comply with the FCRA. The NNA is required to do the background check. Acting as a user of consumer reports is legally obligated to follow the FCRA. What you should do as a notary: understand the purpose. Recognize that this background check is a piece of admission to the high paying segment of the notary market. Now, somebody's going to argue, they ain't high paying. I got it. It's an industry standard demanded by clients, not just not just a whim of the NNA. So it's not the NNA that wants it; it's these other people. And we're going to get into that in a second. Review your rights. Familiarize yourself with the rights under the FCRA. You can find a summary of your rights on the FTC website, Federal Trade Commission. If you have an issue, if your certification is denied or revoked based on the background check, ensure that the NNA provides you with all of that. In summary, the annual background check requirement is not inherently illegal under the FCRA. The controversy usually stems from individual cases where strict procedural safeguards of the FCRA may not have been perfectly followed. As a notary, your best course of action is to understand why the requirement exists and know your rights if you are negatively affected by the results of the report. And then that's the disclaimer. Let me come back to y'all for a quick second. What have I been telling y'all the whole time? You need to take responsibility in making sure you understand. These little snippets and emotional tirades that people have concerning this, and they're not covering the whole thing, and they're just saying it's illegal because they read a statement. Well, we're not employees. You're right, we're not. But employment purposes, meaning you're employing somebody as an independent contractor to do something on your behalf. We're getting ready to get into that aspect, which is that Graham Leachman Bailey argument. Okay. And somebody on Instagram brought that up. So I went and did some research on that. Okay. So another question that people are saying is that the NNA is making millions of dollars. So I'm not going to go all into this, but it's in here. Okay. On the DeepSeek one. All right. So y'all can look that up. So this statement was put out on Instagram. I think it was, Instagram. Okay. About, you're right. The question is, the GM requires financial institutions to protect NPI, non-public information, but it does not, and here's the key word that some people might miss, it does not directly mandate that notaries must have background checks. Title companies and lenders are using this to justify as a justification to push compliance costs onto notaries. The standard, the SPW, I always forget what that said, presents these as recommended standards, but title companies, lenders essentially require them to get work. Okay, so basically what it's saying is that the title companies and lenders are requiring people to do background checks. We're going to cover why. So I asked this question. Another issue that some notaries have is the Graham Leach Bailey argument, the GLBA. The notaries believe that only financial institutions are required to protect non-public information, which justifies their employees having a background check. Thus, they also believe that title companies and lenders are using the GLBA to push compliance costs onto the notary. I'm tired, but I ain't about to pass out on y'all. So it says here, excellent point. This argument is a more sophisticated legal one that gets to the heart of the chain of responsibility in a real estate transaction. Let's unpack the GLBA and why notaries are pushing back on it. And I've learned some stuff in doing all of this. I'm learning even more. And I have to share this with you. This is why I just don't do these little 3-minute snippets and make it seem like, wow, I found some information that is groundbreaking. Now, one of the things you're going to also hold on, let me come back to y'all for a second. One of the things you're going to see in this here part that I'm covering now, the importance of why you need to have legal representation. Just from the first part that I covered, you should see that, you know what, it's important to have legal representation. Yeah, we can join any coalition, any association, any whatever. But the question is, what's the legal representation? Because we need to have attorneys articulating this and doing the proper research. Because when we present this to anybody, whether through a association, coalition, any grouping, or by yourself, they're going to have attorneys that's going to say, here's the legal precedents. Bam. What do you have? What is your argument? Your argument is your limited knowledge of the subject. Your argument is just a few catchphrases, but it's not necessarily legal standing. Okay. And you don't have a legal argument to push back on. You got your emotions and feelings, but you don't have legal standings. All right. So let's keep going. The short answer the notaries making the argument have a valid legal point about the scope of the GLBA, but are likely fighting an unwinnable battle against the practical realities of the industry. I was like, okay, I see, I see. This is where the statement that I said, the notaries are the most important, but they're the least powerful from the standpoint we don't control the money. We don't control the money. And when it comes to having money, the people who have this money, they're like, we need to do whatever it is to protect it. And anybody that's going to have access to it. I'm already telling you where the answer is. If you're going to have access to people's personal information, the question is, what are you doing as a notary to protect that and to give us confidence that we can trust you? So whether you pay for your own background check or we require it, this needs to be done in some cases. So what are you going to do to ensure that we have confidence that you're going to protect this information? So it says the GLBA legally obligates financial institutions like lenders, banks to protect non-public information. Got it? The independent notaries are not financial institutions under the law. However, the lenders title companies are using their own GLBA compliance requirements as a business rationale to impose standards on their who? Vendors. Vendors. We are a vendor to them. So they're saying we want our vendors to have certain things in order for us to maintain compliance, because we want to make sure that you aren't doing something that you shouldn't be doing, or that you have a clean background, as we learned earlier. That's what they want, effectively pushing the compliance and costs down the chain. Here's the breakdown. What is the Graham-Leachman-Bailey Act? Okay. Bill, whatever, the GLBA. What is that? See, this is the thing that you got to understand. You got to understand what these things are that people are quoting, because they're not just one page things. They're like hundreds of pages. So you need to understand, and how does it affect us? So the GLBA is a federal law that fundamentally governs financial institutions, how the financial institutions handle private data of their customers. Who regulates it? The definition is key. It explicitly applies to financial institutions, which includes banks, security firms, insurance companies, and lenders. Okay. Safeguard rules. A core component of the GLBA safeguard rule. This rule requires financial institutions to develop, implement, and maintain a comprehensive information security program to protect customers MPI. This includes employee training and management, information systems protection, and this is where we fall in, managing and overseeing third-party service providers. That is us. They have to manage and oversee us to ensure that we don't do stuff that could get them in trouble. So my question to you, if that's a part of what your job is as an institution, financial institution, then how do you go about doing that? That's why I said earlier, if you talk about get rid of the NNA, get rid of the backer, then what do we have that's going to give them confidence that we are not going to be a problem, that we are not sitting up here as a person who would embezzle money? Because I did a video a couple of years ago where a person took one of those, hold on, where the heck is it at? A person took one of these checks, one of these deluxe checks that was for $25 and tried to turn it into $125. There's a video I did. I will find that and put it in the description. Okay, I will link it in the description. There's a video. It'll either be up here or in there or both. There's a little card up there or it'll be in the description. But a person did that. They literally took a check and tried to change it from $25 to $125. Yeah. Okay. So let's keep going. And sorry for this being so long. This is going to be a little bit longer than the one that I did earlier. So the notary's argument and its legal merit. So there's a legal merit to it. The notary's position is logical and legally sound. We are not financial institutions. That's what everybody is saying. Agreed. Oops. Clicking on it and doing a search. An independent contractor, notary signing agent, or just notary. And I understand it, and I don't agree with the notary signing agent thing. And let's just be clear. Y'all know I've been saying that for years. So all these people who are just now coming around talking notary signing agent, I've been saying that. So don't think that it's new. Go back and look at my old videos. I'm telling you, if you go look at my old videos, you will be like, okay, Griff been saying this stuff for years. It's just now other people have, oh yeah, and maybe they're getting it from my video. They're getting it from somewhere because they weren't talking like this too much several years ago. They are not employees of the bank or title company. Therefore, the GLBA does not directly impose legal obligations on them as it does the lender. The legal obligation rests with the lender and the title company. The lender, as the financial institution, is the one legally obligated to have a safeguard program. The burden of compliance is on them. This is cost shifting. By requiring notaries to bear the cost of background check certifications and specific security protocols, the lender title companies are transferring the financial burden of their own regulatory compliance onto smaller owners, the business owners, the notaries. From a purely black and white law perspective, this argument is difficult to refute, and I agree. The industry counter argument, the practical reality. Okay, despite the legal logic, the lenders and title companies have a powerful, practical, and legally defensible reason for their requirement. Note what I said here, legally defensible. So the moment you start seeing phrases like legally defensible, that means you need to have some legal people to help you counter that. It all hinges on one phrase as safeguard rules right here. This phrase here, managing and overseeing third-party service providers. If you fall within that, that's where they quote unquote got us. We're third party, we're a third party service provider. The vendor management, the GLBA, requires financial institutions to ensure that their vendors and partners who handle NPI are also protecting that data. So that's why I was saying earlier, let me come back to y'all for a sec. That's why I was saying just a few moments ago, what are we doing to protect the person's data? What do we have in place? And we would have to show them some type of safeguards that we have to prove that we are protecting data. Is the folders are you putting stuff on your regular computer, or are you using an external hard drive? Is that hard drive password protected? Do you have proper insurance in case there's a cyber attack on your computer and information gets lost? What do you have in place? Irregardless of the GLBA or this, that, and the other. Okay, the GLBA, we split it, and the notaries don't have to do a background check because the institutions have told us, but still, what do you got in place? What do you have going on that makes us believe that we can trust you? Okay, that's the thing. So then it goes on and says they cannot outsource the work and ignore the risk. So it's talking about the financial institutions cannot just sit here and outsource work and ignore the risk of doing that. Meaning, I'm an outsourcer to Griff, but I'm not going to have any requirements to mitigate the risk that comes. But that's what notaries are asking them to do. Give us the work, but don't worry about what we do. Don't put any requirements on us. Due diligence, requiring a background check on an individual who will be alone with a borrower's most sensitive financial documents is a fundamental and reasonable act of what? Due diligence. Standardization and scalability. A lender working with thousands of notaries nationwide cannot perform individual due diligence on each one, which would encompass possibly doing an interview and checking them out and figuring out, okay, yeah, I can trust you. Next, okay, you know what? I can't trust you. Next, I can trust you. Trust, no trust, trust, no trust. They don't have time to do all of that. They rely on a trusted third party like the NNA to provide a standardized, vetted pool of professionals. That's who we are. A lot of times we're not acting like that, but that's who we're supposed to be. The NNA certification with this background check becomes a de facto industry standard that satisfies the lender's oversight requirement. So if they have a requirement to oversee something, how do they go about doing it? And in this case, the NNA has stepped up and said, we got you. Let me come back to y'all. This is why I'm saying, if you're going to remove the NNA out of the picture and say y'all no longer exist, and I'm going to destroy you and take everything you have to where you no longer exist after 100 some years, what do you have to help these companies in their oversight requirement? That's why I don't give a flying flip about whose coalition, whose association or grouping. If you're not going to help the industry maintain its high level of protection of non-public information for the consumer, then what are we doing? Common sense, people. Use your common sense, as that little clip from R. Kelly said. And he needs to stay his butt in jail. But use your common sense. Think about it. There's something going on here in the industry to protect people. It's not perfect. And now you're talking about we're going to band together and rip apart an industry, a key player in the industry that is doing its best, not perfect, but doing its best and putting forth effort to ensure what these things get taken care of. That there's this protection. But what we're saying is you need to pay us more money. You need to separate us out and don't call us signing agents, which I've been saying that I've always agreed with. Don't call me a signing agent. I'm not. I only use the phrase because that's what people understand. I use the phrase in my search stuff and my hashtags on my videos because it pulls people in. But I don't call myself a signing agent, a loan signing agent, or any kind of agent. I don't. I agree with that 100%. I am a notary. But now you're talking about you want to be paid per stamp on every single thing you do forever and ever. I'm not opposed to that. But how do we get the people who are running and controlling the money to look at it that way? Because there are private businesses who pay a buttload in taxes to who? The state that you are commissioned in. So therefore, who has the power to make them change that on behalf of the notary? And is it a actual legitimate argument that the notary should be getting paid this, which means you need to be requiring that we do something. So then if we're going to do that, then that means we're getting paid more money. Then we need to take part of that money and shift it into doing things as individual notaries to protect ourselves and to ensure that the non-public information of customers is not getting out there and is protected. In other words, we will then bear the cost. Because if you want me to pay you more money, then you need to bear the cost. And notaries aren't talking about bearing the cost. They just say, just pay me money and y'all just keep. Because here's the thing. If they paid you more money, would you be okay with doing a background check? Or are you saying get rid of the background check and pay me more money? Because it's the problem with the background check or not getting paid more money or not getting paid more frequent? What is the issue? And if you're saying all three is the issue, then how do we pull all of that together? What's the plan? When you understand the reasoning, now we got to say, how do you get the people to understand this? Because remember, the people who we're addressing and asking to change things have probably been in this business, the key players, 15, 20 years, if not 30 or 40 years. So how do we come in and make them see it our way? And we don't bring anything to the table. We're taking stuff off. We're asking them to take stuff off the table. And I understand the argument of there's no representation for the of the notaries there. Well, you got to have somebody that's going to be sensible and not act up and not just talk about, well, y'all just need to pay us more money. The bottom line is, how do we protect the consumer? And if you're not doing things to protect the consumer, that's a problem. All right, let me keep going. So risk mitigation from the lender's perspective, it is a simple risk. It's simple risk management. If a notary steals or leaks data, the lender faces regulatory fines, civil lawsuits, and reputation damage. They will do everything in their power to minimize that risk. And a background check is a basic, justifiable step. If you're not getting this as a background check, one section is like 30 some pages. Electronic questionnaire for investigation question. Let me just share with you some of the questions. So it starts off asking my name, identifying information, telephone numbers, my citizenship, my mother's maiden name. Do I have dual citizenship? Where have I lived? I have to list all the places where I've lived, references, where I went to school from, employment activity, the dates, and had to note when I was unemployed. So if there was a time period that I was not working, I had to denote that on here and say from this date to that date, I was unemployed. All of this is employment. About 10 pages of employment stuff. This is going back to 1998. This is going all the way back to 1998. Then all the people who know me. Then spouses and former spouses. Citizenship of and relative associations. Then all my relatives. Do I have any brothers? My mom, my pops. Whether they got middle names. Or are there any children, adopted children, this, that, and the other? My children. Then my military background. Foreign activities. Foreign countries I've visited. Medical record. All of this kind of stuff. Do I use illegal drugs? Police report. Investigation record. My financial record. Financial delinquencies. Public civil court actions. And that's it. That's just one section. Then I had to sit there and type all that stuff out. I had to manually type that stuff out. That was the notary. Then I had to go in there and go through and type all that stuff out, manually do it. And I think I had to do it 2 or 3 times. So unless you're doing that one background check investigation, that's a lot. So let's close this up. It says conclusion. I said collusion. Conclusion. A clash of law versus market power. This is a classic case where legal correct positions collide with market realities. The notaries are legally right. They are not, they are correct that the GLBA does not directly regulate them. And note what it says directly. They are correct that this is a form of cost shifting. But the lenders hold the keys. Why? Because they control the daggone money. The lenders control the work and the flow of money. They have the legal obligation under the GLBA to manage their vendors and a business imperative to mitigate risk. Therefore, the requirement is not an illegal misapplication of the GLBA, but rather a lawful and logical trickle down of its requirements through the vendor selection process. A useful analogy is a general contractor on a construction site. They are generally responsible for the oversight or the overall site safety, the lender's GLBA compliance. So the general contractor, the head contractor, is in charge of making sure the safety of the work site. To meet that obligation, they require every subcontractor, the notary, to provide proof of their own safety training and insurance. The subcontractor bears the cost, but the requirement flows from the general contractor, primarily legal responsibility. The bottom line for notaries: fight this on the grounds of the GLBA doesn't apply to me is unlike fighting this on that ground is unlikely to be successful. The title company's response will simply be, you are correct, it applies to us. And to meet our obligation, we only hire notaries who have passed a background check. It's a standard part of our vendor selection criteria. For a notary, this means that like a background check itself, complying with the security expectations driven by the laws like the GLBA is simply the cost of entry into a professional mortgage signing market. The argument, while legally interesting, does not change the practical requirement to participate in the industry. Did you know, did you ascertain all of that from a 3-minute clip? Make that make sense. And y'all can take it however you want. You can take it personal. I don't give a flip. Because personally, I'm tired of this arguing about these things that people don't have any true legal basis to fight over. So if you're going to get into a fight, you better know what the heck you're fighting for and who you're fighting against. And you better make sure you have the necessary people backing you in this fight. Get out of your daggone emotions. And that's where a lot of y'all are resting at. The people who are saying this, as well as y'all who are following it. You are caught up in your daggone emotions. I wish the National Notary Association would just come out and just articulate their position on all of this. They don't feel as though they have to. I get it. But that's what they need to do. Maybe y'all need to contact the National Notary Association and ask them to explain it. And I think if they get enough of you calling them and asking them, maybe they'll come out and say something. Maybe they need to do that at their next conference. That's what I think. At the NNA, I'm asking you at your next conference, at your next whatever you do in between the conferences, you need to start talking about this. Everything that he and she and them and they are talking about and blame and accusing you of, y'all need to start addressing it and putting all this stuff to bed. Now, people still want to have that argument. Well, I just believe that I'm right. I just believe. Show me legally that you're right. Get me an attorney and have that attorney argue this and issue whatever class action or single action or double piston or whatever lawsuit that needs to be done in order to prove these points. And now help me and us understand the pathway forward. What is the pathway forward? We've been here 45 minutes and covered a heck of a lot more than what you learned in 3 minutes from somebody just making statements and showing snippets of information. And in the snippet itself, it said, keep saying what? Directly. But there's an indirect avenue there. And if they have a legal requirement, the lenders and title companies, the financial institutions to protect, well, mainly the financial institutions, but even with the title company, they handle all that escrow money. You talking about you want to collect somebody's check? I want to make sure you ain't nobody crazy. Now, of course, you can still do it, whatever, but at least got a background check. The background check should say that you're somebody trustworthy. What's wrong with having a background check? You see, the one I had to do, and I had to do that, I think 4 or 5 times. I had to go through the big background check. There was little background checks and then the big one. So I understand the argument. That's really why I never said anything, because I'm like, okay, I get it. I never really dug into it, but just from a common sense perspective, I get what the argument is. But I said, if they are doing this, they have to have a reason. There has to be something out there that supports them saying, we need to take on this. And now I understand. And I hope you do too. Now, from this point forward, see, anything that somebody says, you need to do the research. If you're not going to do the research and you're just going to sign up for stuff and start tossing out your money, oh, wow, yeah. We're going to get there. Yeah. 1:13. That's what time it is. You have at it. But based on this, I don't see how they have an argument unless they come and say, we'll take on that responsibility ourselves of doing a background check, but they still going to want to see the background check. So if the issue is that you don't want to do a background check, excuse me, a background check and give somebody access to it, then you might as well not even be in this industry. This is part of the reason why I keep telling y'all, get out. Because you don't want to do what is required. And how do you expect to make, you're talking about opening these people up to risk and you want them to pay you more money. You're increasing their risk and you want them to pay you more money. And I'm not saying that the $75 or this, that, or the other is fair, but if you want more money, then you got to move the signing companies out the way. And now the question is, how do the title companies have a pool of notaries to pull on that they can trust? How does that happen? Who's going to take over that responsibility? What are you going to do to be that? What are we going to do? Because you don't need a group. We don't need another association, coalition, or whatever issue to say, I'm going to do right. All you got to do is make up your mind and say, you know what, I'm going to do right. That's what I'm going to do. So let me go before I be up here for 5 hours and I need to get me some sleep. I'm tired. I suppose I've been cleaning up. Got my docs printed for tomorrow. Still got 2 sets of documents I'm waiting on. Got 6 tomorrow. Good day tomorrow. All right. So give me your thoughts and comments in below. And we need to have this conversation and discussion. And y'all need to start asking questions, detailed questions. And you need to start defining words and making sure you understand the true intent of these different things that they're pointing out. Because if you want to go and talk about the Graham, the GLBA, then let's get into the Sherman antitrust. I already put the links in the other description for that, I'm gonna put the links in this one. Go read the Sherman Antitrust Act, because that talks about competition, about price fixing. And that's what this is leading toward, trying to fix the price and force people not to be able to compete, and not giving people the option to negotiate and stuff, because it's like, no, you got to pay all notaries $150. No ifs, ands, or buts. Or you ain't gonna want to pay us $150, then you got to pay us $25 for each notarial act that we do. No, there's no negotiating. No, it's this and that's it. Remember, that's what got the National Association of Realtors in trouble. That flat fee thing, or that 3% or 6% or whatever they was doing, got a lot of people in trouble because it wasn't negotiable. Go look up the justice system, the justice department, the cases they got right now against Apple. Go look up the old Microsoft stuff. This is a real thing. America is built on freedom of competition, a free market. And what some of you notaries are talking about is talking about putting the notary industry part in chains and removing the ability to negotiate and to have free market reign of competition. That's what you're talking about. So if you want to pull up an act, go pull up the Sherman Antitrust Act. Let's see you talk about that. They don't talk about that because it will destroy their whole argument and premise of what they're doing. All right. Y'all have a good one. I'm going to go to sleep. 1:17 in the morning. Talk to y'all later. Peace.